Ready, start. According to the High Court, when Section 50 is read carefully, everything becomes quite clear. The whole section is about recovery of money due to an employee. It allows employee to apply. It allows another person to do so only if that person is authorized by the employee. So the focus is on the employee and his dues. The petitioner is trying to say that in this context, the word employee should be read as including union. But when the section itself repeatedly refers to employee and even adds a condition of written authority, then such reading does not fit. In fact, the context shows clearly opposite. It shows that legislature wanted to keep this remedy limited to employee and those directly authorized by him para. It must also be noted that Section 50 is not a general recovery or execution provision or all types of claims. It is a special provision made for a specific purpose. It gives a remedy in a defined situation. If it is treated as a general provision, then its careful wording will lose meaning. So, the object of Section 50 is to help an employee to recover already found due to him. The remedy is not open ended. Because of this, the court also has to act within these limits. The court cannot expand the section just because it may appear useful in a given case. Therefore, it becomes clear that context in this case does not help the petitioner. Instead, it supports plan reading of the section. The definition cannot be stretched to include union. The limits fixed by law must be respected para. A court has to see what the law provides. It cannot change the law because a party feels that the available remedy is not sufficient. If the legislature has made provision in a particular, then that method must be followed. The court cannot open a new path just because the existing path is difficult. Sometimes law may not cover every situation, but that does not mean that court can add new provisions para. If the legislature wanted the union also to apply under Section 50 in its own capacity, it should have clearly said so. The absence of such a provision cannot be treated as a mistake which the court must correct. The court's role is to interpret what is written, not to feel what is not written. Even if the union finds itself in a difficult position, that alone cannot justify expanding the scope of Section 50 para. On careful reading, the argument of hardship cannot be accepted. The absence of written authorization is a serious defect, and the interpretation suggested by the petitioner would unsettle the clear scheme of the Act. All the factors together make it difficult to accept the case of the petitioner. The High Court has dismissed the petition.